If your insurance claim has been denied, then this is for you. Welcome to the Policyholder Podcast. My name is Danielle Snell and I'm the co-founder and managing partner of Elit Lawyers. Each week, we meet with legal experts and industry insiders to delve into real-life cases of insurance denials, discuss common trends and patterns, and talk about strategies to navigate insurance issues. Whether you're a policyholder seeking to challenge an insurance declinature or a legal professional seeking to navigate the complexities of insurance law, this podcast will provide practical steps to help you take that next step. The Policyholder Podcast starts now. This morning, we're delighted to introduce Jeff Gleeson, King's Counsel, to our show. Jeff practices in general commercial law and specialises in construction, building and insurance matters and also sports law. We've had the benefit of working directly with Jeff, and what really stands out to me about you, Jeff, is just how you can simplify the most complex of legal issues and explain them to clients, and it really sits in well with the policyholders that are going to be listening today, just because all they want to do is understand the ins and outs. And so thank you for being here with us today.
Absolute pleasure.
Welcome, Jeff.
Thank you.
Jeff, to start off with just understanding the insurance landscape, what are the most common types of disputes you think arise in insurance cases?
So my exposure to the insurance dispute world has largely been in relation to non-disclosure. I started decades ago now running non-disclosure cases, typically for the insurer, but not always. I still think to this day that's perhaps the most typical sort of dispute, leaving aside general insurance disputes dealing with some of the more complex policy wordings where, does an exclusion apply, which is much more akin to pure contract law, really. It's the proper construction of a clause, whereas non-disclosure cases, the failure or alleged failure of an insured to tell the insurer something that might affect the insurer's decision whether to insure the person, that permeates across all types of insurance, life insurance, general insurance.
Just as some examples for listeners, what are the sort of key, have you seen some common non-disclosure incidents where there's something in particular that policyholders or the insureds are failing to tell the insurance company before the policy is incepted?
I think there's two types. There's the deliberate decision by an insured, which is a rare case, but a deliberate decision to try to hide something that they're either embarrassed about or they think rightly or wrongly will mean that they won't get the insurance. Now, that is a very problematic case because the person's turned their mind to it and they think, look, I won't tell them this and I'll cross my fingers and I hope they don't find out.
It's a deliberate
failure to disclose. More commonly, I think, is people not sufficiently turning their mind to the question of what the insurer would want to know. And that can be a quite innocent process where people in general insurance don't really think about what the insurer is curious about to know whether to insure them and if so on what terms and for what price. And in life insurance, it becomes perhaps a little bit more of a human process where some people might have had a health issue which they think or hope that they've put behind them and they've almost blocked it out. Or they didn't think it was a big deal. So those are the two categories. And I think the process of sitting down and thinking to yourself, okay, I'm going to undertake that rather distasteful task of pretending to be an insurer for a moment. Think about what would they want to know.
Yes, that's really good advice.
That's the approach people should bring to taking out their insurance, because we can talk about this in a bit more detail, but what a lot of people don't realise is the insurer doesn't have a freestanding obligation to go and investigate every aspect of your life or your business. And people think, oh, well, if they don't find out now, then I'm good to go. of course, that's not the case.
It's interesting, Jeff, those sort of cases of non-disclosure, I assume that a significant part of the evidence at trial in most of those cases would be underwriting evidence about what the insurer would have done had they known.
Yeah, absolutely. There's two main evidentiary aspects to it. It's what did the insured know, or what should they have known given all the circumstances, and that involves a factual inquiry that's quite discovery heavy. That is, the process of discovery in litigation, which is you hand over your documents that are relevant. So insurers, both in the investigating stage of investigating the claim and the inception of the policy, and thereafter, will typically get access to a lot of documents that will shed light on what the person or the business knew or should have known. So there's that evidentiary aspect. And then there's the underwriting aspect, which is typically the insurer will roll out the underwriter, if they can, the person who sat down 5, 10, 15 years ago and underwrote the policy, assessed the risk. The underwriting world's reasonably small, so but a bit nomadic. So you get individual underwriters roaming around different insurers, but they tend to stay in the industry. So they get hauled in to talk about a file, which is one of the many thousands they've underwritten. They look back at their notes, they reconstruct, understandably, what they think they did. And then there's the grand hypothetical that hovers over all the non-disclosure cases, which is, what would you have done?
It's interesting, from a policyholder's perspective, a mistake that people often make when they are going to take out insurance is they look at the policy schedule, which is usually about 3 pages long, and don't spend the time to have a look at the product disclosure statement, which is often, sort of at least 50 and sometimes 150 pages long, and the devil's in the detail with the PDS, and so that people who are insuring for whatever business risk need to not only review the policy schedule, but understand at least the exclusions and other matters contained in the PDS.
Yeah, I couldn't agree more. I think insurance is getting more and more complex, and insurers are understandably trying for their own commercial benefit to write plain language policies, but that in itself is a fraught process. I mean, there was a case I was reading that it was only judgment only delivered a few days ago, and Justice Derrington spoke about the fact that insurers want to and need to explain things in plain English, but that can result in creating more problems than it solves. But it does fall to the insured to do what they can to read and understand the product they're buying. And I think I'd urge potential insureds to get advice, not only because it gives you someone else to sue if things go wrong,
That's true.
Seriously, it's a complex world, and you can get advice that'll help you not only compare products, but even negotiate a better outcome in terms of adjustments to or removal of exclusions, as well as the premium, which people focus very much on the premium at the outset, and they're not at all on the premium when it's claim time.
We find, Jeff, when policyholders first approach us that there's usually been a protracted history and that they've already submitted their insurance claim, and there's been a number of document requests, and by the time they reach us, sort of say, oh, we wish we'd seen you earlier, and they are quite struck by obviously the delay and the protracted history, but also they want to understand more. And it goes to the other example you gave around there's often a declinature by the insurer either for the full claim or there's a quantum dispute, meaning that there's an argument. The insurer says, we only need to cover you for X amount, whereas the insured says, I should be covered for a much, much higher amount. In those sorts of, by the time the case reaches you, it's usually sort of the disputes crystallised quite a lot. And what sort of key issues are you seeing when it's an exclusion or a policy argument between rather than non-disclosure, that is, where it's something to do with a declinature because of the meaning of the policy or some term that's contained within the policy?
The point you made at the outset there about the lawyers often only entering the fray when the claim's well developed or poorly developed, as is more typically the case, is really fundamental. I think people in a commercial setting who are used to dealing with commercial processes, negotiations and commercial dealings often bring that sort of sensibility to bringing an insurance claim, which is, look, I'll just get this thing done. I'll just tell them, to the best of my recollection, what our business is about and what happened and how it happened and what we did. Those early comments in claim forms or information provided in claim forms can be really damaging if they're not quite accurate, and insurers will seize upon that if subsequently, having been properly advised and gone back through the records and familiarised themselves with the process, they've realised, hang on, what I said first time when I shot from the hip wasn't quite right. It's very hard to walk it back.
It is, yeah.
So the earlier you get good legal advice, the better, and it's better to take a little bit more time, investigate it properly, and give the insurer the information that accurately captures the nature of your business, what you do, what happened, and then you're a better chance of perhaps not falling into an exclusion clause that you might have otherwise avoided if you gave not tailored information, but information that was conscious of and spoke to the exclusion clause and why you're not captured.
When you're reviewing a policy, Jeff, but you're acting for the policyholder, the person or the company that's taken out the policy rather than the insurer, do you look at different? Is it a different perspective? Are you preparing the case with different focus, or is it largely the same?
Look, I think it's probably largely the same, with one caveat, which I'll come to. It's largely the same because the nature of dispute work, once you're getting to trial, is that you're constantly trying to anticipate the opposite argument. So you're always testing yourself with the opposite argument. So if I'm acting for an insurer, I'll always look at what counsel for the insured will be saying or likely to say, not just in terms of things that they've pleaded and so you've got a fair idea of where they're coming from, but what they might do even by way of cross-examination of the underwriter or that type of thing. But the caveat is a human one, and that is we are inclined to take on the mindset and position of our client to some extent, which is a healthy thing. As long as you've got sufficient detachment as a lawyer to understand that your overriding duty is to the court, and that if you get too close to the client's position, you're not really doing them any favours because you're not detached. But we are hardwired to see the story of the person who tells us the story. And so I suppose I'm conscious of that I will always be looking at the policy and reading the exclusion clauses if I'm acting for an insured, burdened favourably with the knowledge of that insured's business and situation. So I'm trying to help them get the outcome they want.
I think that's right. What really struck me is, having done work for insurance companies previously, acting as a solicitor on the other side, you're seeing people's lives. They've often worked really hard for the business and they've taken out the policy to cover that very sacred asset, whether or it could be a personal asset. And so they're up against a sophisticated litigant in obviously taking on and challenging an insurance company. And so I see this tug of war in the sense that they want to feel more heard and they don't want to be a number, but obviously the harsh reality is, isn't it, that they are a number in terms of from an insurance company's perspective, when there are lots of claims involved and the like. So as you say, it's about having a measured approach and providing independent advice, but still understanding fundamentally what our insured policyholder is going through.
And of course, they can get the advice. Usually, large businesses will deal with brokers. They'll have an understanding of the insurance market. They'll have an obligation to the insurer. There are often policies that have claims preparation costs where they can engage and claim from the insurer loss assessors. But I think it's important the point you raise that, if it crosses the threshold of a significant claim, that it's important they get appropriate advice at the earliest opportunity, not at a later point in time.
Absolutely. It can literally be too late if they've made statements or concessions that you just can't walk back. Then there's only so much the lawyers can do.
One of the great frustrations we find with the policyholders, Jeff, from our perspective, is not understanding that how the procedure is determined time-wise, because there's no requirement under a policy that it must be dealt with in a particular time. We go to the General Insurance Code of Practice, and that provides a 30-day time limit. But of course, time and time again, the insurers will write, as they're entitled to do, and say, well, we can't make the decision in that time. We need more information. Give us more information. And the obligations that the insurers got. Clients are frustrated with that process, and it's important that they get advice about that and what they're entitled to ask. And as you pointed out to a number of clients, the ability to write to the insurer, Danielle, and ask for copies of all of the expert reports that they've considered to date.
Which they're entitled to under the Insurance Code of Practice, which often many policyholders are not aware of, or they've submitted to interviews and they're entitled to the transcripts of those interviews. And so in order to provide advice to the policyholder, we need to also be furnished with as much information that the insurance company, especially if the insurance company have declined the claim in its totality, we need to understand as much as possible about the insurer's position. And so that leads me into my next question, Jeff. There was a case that we worked with you on sometime last year or the year before that, where we were acting for the Mariner Group, who are the owner of Melbourne theatres, including much beloved Princess Theatre, and they had sustained business interruption losses as a result of the COVID pandemic. And ultimately, we ran the case to trial. You weren't involved at the trial stage, of course, but we succeeded in that case, and the judge found that the policy did apply over two separate policy periods, and the sublimit applied per premises. And, I was interested in your thoughts about just the high level kind of key takeaways or the observations that you have from that case as to what stood out. Was there something fundamentally when you looked at it initially that the reason you formed the view that it was a case worth pursuing for the Mariner Group?
Sure. So I was really disappointed not to be able to run that to trial. I got jammed, but the more accurate view is that I, for the client's benefit, got the hell out of the way, and Chris Archibald and Nick Petrie and your good selves ran it home to victory. It was a fascinating case. It came in the context of the COVID-19 pandemic, and it was essentially a business interruption style claim, and it came against the background of a series of rather fundamental and spectacular losses by insureds in what we might call test cases. And so there was a bit of a pall of misery around the ability of an insured such as our client to succeed in that sort of case. But we, and I know you and I, you collectively and I formed the view that there were some points of difference here.
There were.
And that really is, to answer your question, the takeaway is every case that involves the proper construction of the contract and the application of the insurance contract turns on its own language. There's a bit of a fallacy out there, I think, among some insureds that all the policies are basically the same. That type of policy is the same as its brother and its sister and its cousin. It's not true, and the outcome of cases can turn on one word. And the insurers spend a fair bit of time and energy and get legal advice in drafting their policies. I know this from firsthand experience, that they try to pitch it at a level that gives them the maximum protection, of course. They're a commercial entity.
Yes.
But there's always tension between the underwriting department and the sales department, so to speak. So the lawyers want a watertight policy to be written, but all the agents and brokers out there know that to sell policies, you can't have it too tightly worded. So there will always be that tension within the insurers, and that plays out in litigation where you've got different wording that might be seen to be and might actually be more attractive to the insurers. So getting back to the case we're talking about, the process of internal compromises by the insurer around language, the evolution of the policies over year in, year out, and the slight changes resulted in a pretty ad hoc set of pieces of paper that had to be cobbled together in this matter to form a policy. And it was a mess.
It was.
It was a mess that the insurer, I think, should be a bit embarrassed about, because we think that they're a highly sophisticated organisation and all their documents are streamlined, and yet in the end, I think even they would admit that it was all over the place. So what stood out really was that there was the prospect of not falling into that category of cases that had already been run, the so-called test cases about COVID-19 style business interruption claims, that we might step outside it. And that proved to be the outcome, that it really turned on the meaning, at one level, turned on the meaning of following, the word following.
Yes.
Was it a temporal? Did it just mean following in time, or did it mean following as a result of? Now, lawyers love that sort of stuff. Insureds probably think we're mad, but on that turned a really successful outcome for these insureds.
Why do you think, Jeff, that some insurance cases fail for policyholders? What do you think the main reason?
I think there's an element, another human element that comes to play is the philosophical bent of the judge. Now, we all like to think that the judges are this sort of homogenous lot who, if there's a contract and it's worded a certain way, then they'll all interpret it that way. We know from appellate cases where there's typically 3 judges, you'll often get 2 go one way and 1 go the other way. Now, if they were the judges at the trial level and you only get 1 judge, which one did you get? The one that interpreted it that way, or one of the 2 that interpreted it the other way? So there's that element, and that comes to play with their degree of sympathy for the position of the insured. Now, judges would say that's nonsense. Doesn't come into it. If I'm interpreting a contract, I'm interpreting a contract. We're human beings, and at a subconscious level, if it's a 51 to 49% argument, which way it's going to swing can come down to your general philosophy that you might, without even knowing it as a decision maker, have a slight inclination to uphold the defence of the insurer or the claim of the insured. So I think there's an element there. Why else do they fail? I think we've touched on choosing the wrong policy.
Yes.
I think we've touched on not getting advice early enough in the claims process. And I suppose the third one is a lack of realisation by some insureds that once you're in this disputed claims arena, there's nowhere to run and nowhere to hide. Everything becomes transparent.
Everything's on the
so
table.
If you think you're going to get away with a little white lie, a little fib, because that's not important and that shouldn't matter, it will matter, and it'll blow up, and you'll suffer the credit outcome adverse to you that you might have avoided. Properly advised, the lawyer would say, don't worry about that. Just don't tell that little white lie. Don't tell any lies. Turn up in court as the white hat, and you'll give yourself a chance.
It's interesting, Jeff, that it goes back to you were talking about non-disclosure, and it highlights the issue of duty of utmost good faith. And perhaps if you could tell us your view about that and how it applies in the context of insurance, both in respect of the insured and the insurers.
Sure. So for centuries, really, it was a phrase, duty of utmost good faith. It was most typically applied to the insureds. And I think a healthy development has been in more recent decades in Australia. It's been turned back onto the insurer that they've got to play fair as well. Mm-hmm. So good faith, what does good faith means? It means you need to act reasonably and honestly. And it's supposed to be supercharged by the adjective utmost. So it's not just common garden variety good faith, it's the utmost good faith. So when properly applied, it should mean that if an insurer acts in a sharp way, where it takes a point that really it's a bit unfair to do, then it won't be permitted to do so. And similarly with an insured, if they're telling a little bit of the story in a non-disclosure context, but not enough to give the phrase that's often used by the courts is a fair assessment of the risk. As long as the insured gives the insurer a fair chance to find out what risk it's taking on, broadly speaking, the insured has complied with that duty of utmost good faith. Mm-hmm. But it's a malleable concept. And again, we get back to that philosophical approach of the bench. It can be fashioned to some extent to fit an outcome that feels fair.
And it's also goes back to the point when insureds are filling out applications for policies, it's absolutely critical that they make disclosure, and the questions that they're answering there are designed by insurers for the specific purpose of determining whether they'll cover them for the insurance, and if so, with what premium. And to the extent that they misstate or give a wrong answer, it'll come back to haunt them at a later point in time.
It will, and at the worst possible time. It could be years later. And what insureds frequently don't understand is that you haven't won the battle because they gave you a policy. Yeah. Because the law is they've given you a policy based on what you told them, and 5 years later you make a claim and they investigate more thoroughly what you told them and its accuracy and honesty, and it can fail then. But there was a case recently decided in Australia where an insured put on its answered a question. The question was to the effect of have there been any facts or circumstances in the last 5 years that you are aware of that might potentially give rise to a claim? And the insured answered yes and gave no more information. Mm-hmm. And then it went through and the underwriters mucked it up and didn't follow up and ask. And it went all the way, I think, to the Court of Appeal in New South Wales. And the answer was, well, the insurer had waived the obligation to give more information. Mm-hmm. Now, I'm not suggesting that's a good approach generally by insureds, but the court was satisfied that that wasn't sharp practice by the insureds. They just didn't fill the format properly. But they certainly put the insurer on notice.
What about this, Jeff, just going back to the obligation of good faith, just at a very high level and as an example base, what we're often seeing is that we've got policyholders that there's an event that's occurred. It might be hypothetically a property, it might be a commercial property, a personal property, but something's happened and that it was an insured asset. And quite a lot of time then passes because what's happening is the insurance company is quantifying what the loss is and what needs to be paid out pursuant to the terms of the policy. What would you say hypothetically that is if an insurance company is undertaking the exercise of investigation, obtaining necessary quotations and rectification scopes and the like, but the sorts of amounts that they're offering prove to not be high enough. And what we've seen is many years can then pass, and ultimately, if it does say go before the courts or through some other alternative dispute resolution process, the quantum of the claim works out to be quite a lot higher than what was ultimately profit at the outset. Do you say that an insurer's obligation extends to taking sort of fulsome steps and presenting more accurate cost assessments and the like from the outset? Do you think that adverse findings could be found against an insurer that's not undertaking those steps diligently throughout the course of a claim?
Yeah, absolutely. It comes down to a question of what was fair and reasonable in the circumstances, and there'll always be a reasonable range within which reasonable minds might differ. So you're talking about experts, and the example you gave is about a commercial property related matter where the insurer was obviously getting quotes or assessments that were very conservative, pretty tight-fisted. If it's within the range of what reasonably might be expected, I think the courts will not regard that as a breach of good faith. But in a life insurance context, it's a little bit like somebody claims a medical condition or a serious medical condition, and typically when you're in the arena of illnesses that don't have readily objectively identifiable symptoms. So a lot of your chronic fatigues, your mental health type issues. And if the insurer goes off and gets an expert opinion from a medical expert that runs against the very strong tide of 6 others going the other way, the courts will take a very dim view of that and say, well, that was clearly an outlier. So no matter what the area of expertise or method of quantification or assessment of liability, the insurers, the days of insurers being able to pick off claims by getting one favourable report that's outside the range, I think, are gone. And the courts are understandably taking a pretty dim view of it.
Not all policyholders even understand, do they, Rob, that they can go out and obtain their own expert reports, because especially if they're not at litigation stage yet and they're just going through the claims handling process, and the insurer's obtaining its own expert opinions, but they don't realise that they can do so as well, and that's often part of our advice, isn't it?
It's a consistent problem we're seeing, particularly with, very expensive houses, commercial properties. The insurers have their experts who happen to provide a quantum assessment that suits them, and it's a risk-reward ratio and what it costs, but it's important sometimes to get an independent quantity surveyor expert to determine that question as to whether it's within the reasonable range.
Yeah, absolutely.
And that's a frustration for a lot of policyholders.
Yeah, and it's another expense. You can understand why insureds think, well, do I want to go and pay an expert? And it's a question of the relativities here. If they're under by a significant amount of money, then paying for an independent expert is money well spent.
Yeah,
exactly.
Well, one of the issues in any insurance case is this question of the liability assessment, but that's only half the question. And as Chris Archibald said, the rubber hits the road when you're dealing with causation and quantum, and that's where a lot of expert evidence can be required.
Yeah, and it's it's very technical typically, and depending on the nature of the loss and the nature of the client's industry that they're working in, it can be, for us as lawyers, something that we need to lean on the experts very heavily. Because much as we like to think we know everything, there's a whole world of commerce and industry out there that's very specific to that client's area. And it can be a real mistake to get, and you see it a lot, insurers will get someone who they think, oh, that expert knows that area, but in fact they don't at all, and they're assessing something quite different to the insured's business. So finding the right expert is really, really important.
Agree completely on that. Another question I had for you, Jeff, and this is an anomaly, it might not come up as often as what it doesn't come off all that often, but we have seen it, haven't we, Robert, where there are certain policyholders that come to us and they've taken out a policy. It might be a professional indemnity policy, or it could be some other sort of policy, but they've lodged the claim and the insurers declined on the basis that, for example, I'm thinking of one where they said there's an alleged breach of an Australian standard, so your policy does not cover you. And when Robert and I have looked at it, we've thought, well, what was the very point in taking out the policy in the outset? Because as you'd appreciate, to have a professional negligence claim made against you, it would typically occur that there'd be some sort of allegation of a breach of an Australian standard. And that's just one example, but we've seen others where the very policy in itself wasn't really worth taking out if the terms applied to the full extent. Have you seen any cases like that or instances where the terms are grossly unfair?
Yes. Typically, it arises in circumstances where there's a perhaps an exclusion clause, or even the policy cover language has got some ambiguity about it. And the position taken by the insurer in the dispute is to read that ambiguous clause in a narrow way, and then you stand back from it. And this is the point you're making. You stand back from it, you realise that, well, if you read it that way, that is a worthless policy.
Exactly right.
And the courts have been pretty astute to reject that sort of approach. Whether it be an exclusion clause that, if read the way the insurer wants to, is so broad that it captures almost the entire universe of potential claims. So again, it's something that without legal assistance, insureds can receive a declinature letter that, read at face value, can sound sort of, arguable. Okay, yes. Well, that the language says that, and they reckon the language means that. Well, that's the end of it, without having the insight to realise the broader implications, because insureds understandably are very focused on their claim.
Exactly.
And they think, my claim's failed, without turning their mind to, hang on, that means every claim would fail, or almost every claim.
And insurers can get it wrong too, can't they?
Oh, absolutely. And, having acted for insureds and insurers over the years and been briefed to advise insurers on the language of their own policy, it sometimes amounts to them saying, what did we mean here? And they have inheritance issues where, someone who's long gone drafted this language 10 years ago, and the poor schmucks who are sitting there trying to deal with it now don't quite know what was intended by it.
Okay, well, I think we'll move on to the rapid fire round now,
Goodness.
Jeff, if that's okay. So it's one myth about insurance you'd like to bust.
That, and it's a non-disclosure answer, that it's only non-disclosure about the subject matter of what turns out to be the claim that matters. So people think, quite understandably, okay, well, I didn't really disclose to you that I had a potential claim in the wings by some disgruntled employee. I didn't disclose that, but my present claim's got nothing to do with that. So that's all irrelevant. That's typically not the case.
Yes.
And the myth that needs to be busted really, I think, is that the only relevant non-disclosure is the one that attaches to your claim. People need to think of it from a different perspective, insureds, and that is, if I had told them this thing that turns out I should have told them, would they have given me the policy?
That's right.
Because the insurer's position is, well, if I wouldn't have given you the policy, I wouldn't be on claim for this perfectly valid claim. Yes. So that's the
When
issue.
An insurer says, though, if you'd told us this, we wouldn't have given you the policy, how do you often see that being tested? Because is that through underwriting manuals and evidence that ultimately is borne out during the case? Because we have see that a bit where they've said, well, and we think, well, and this is obviously subject to the circumstances of the case and pursuant to the particular type of policy,
Sure.
but insurers can often say that. They can often say, we wouldn't have given you cover. And when we sit back and look at it, we think, well, we think they probably still would have given the cover. How do we test that?
Firstly, through discovery. I've been involved in more than one case where the court has given discovery in favour of the insured of other claims, other files where a similar disclosure was or wasn't made, and what was the outcome at an underwriting level.
And I've gotten into arguments with opponents around whether or not that constitutes discovery, because they're obviously related to other claims, and then we've had to seek specific discovery orders and the like, because, but all these sorts of, they all relate to causation, don't they, as well?
Yeah. They can be really worthwhile fights, because insurers are big and sometimes cumbersome industries, and the underwriting departments won't always have had a consistent approach. You can have a dozen underwriters in the one insurance underwriting department, and it might be that over a 5-year period, when you look at similar sorts of proposals that have been put in, they've been treated differently, and so it can be challenged there. It can be challenged, as you touched on, at the underwriting guideline level and what they provide, because the position being adopted by the insurer might or might not be consistent with the underwriting manuals and guidelines that exist. And ultimately, it's a problem area for insurers, because, as I touched on earlier, it's a nomadic industry, and if the underwriter has moved and left the particular insurer on bad terms, they're not going to turn up and give evidence. So it's a very practical issue that you don't really know for sure. But if you're getting to the stage of litigation where there's witness outlines being put in, you then know, hang on, are they calling the underwriter, or are they going to try to discharge their onus? And it is their onus. It's up to them to prove what they would or wouldn't have done. Are they going to try to discharge their onus by relying on others?
Someone else, yeah. Next rapid fire.
That wasn't very rapid, sorry.
It was partly my fault, because I asked more questions. One legal term every consumer should understand.
Legal term. Look, I'm going to go with disclosure. I know it's a bit flavour of the day, but we throw it around like confetti as lawyers, and we have to stop and think, hang on, does the insured really know what it means to disclose something? And it's so closely aligned to the word relevant. You don't have to disclose everything. You only got to disclose what's relevant. Gets us back to the position. Insured, what you need to do is sit down, pretend you're an insurer for a minute, and think, what would I want to know if I was trying to decide whether to give this person a policy?
Yes.
That's it.
Yep.
Excellent.
And just to finish off, for any policyholders that are listening to us today and they are in a situation where they have been denied cover, and they're, needing to take that next step, is there any parting advice that you could give them, other than what you've already?
Look, I would say go and see Danielle and Rob.
Thank you so much, Jeff.
And otherwise, I think prepare yourself for the fact that you are entering a battle with an institutional litigant. Now, what does that mean? It means somebody who, as part of their business, has fights like this. So they're not emotional about it. They're doing their job.
Good advice. Yeah.
And you should approach it as part of your job and your business to approach it with a hopefully similarly detached mindset. It's not going to be quick. It's not going to be easy. It's going to be frustrating, but persistence and patience and, dare I say it, courtesy actually go a long way. If you present to an insurer as a rabid zealot, it's a human process at the end of the day. Your card will implicitly be marked difficult.
Yeah,
we've had instances, excellent advice. Yeah. Thank you, Jeff. That was wonderful.
It's a pleasure.
Thank you very much, Jeff.
Really enjoyed the chat.
Wonderful.
Okay, thank you.